Hello, and welcome to a discussion of the important subject of how to avoid conflicts of interest. To my right is Bill Diedrich. He's a partner with the law firm Atkinson, Andelson, Loya, Ruud Romo, and for at least the last decade or more, he's been representing public school agencies in board and governance matters as well as labor and employment.
And to my right is Mark Thompson. I've worked with Mark since 2008. He's been my boss since about 2013. And Mark is a partner with Atkinson Andelson. He's also the managing partner of our Riverside office. And Mark, I always view Mark as an answer guy. Anything that comes up that's the type of thing that board members or superintendents are plagued with, Mark's the guy that knows the answer to all of those questions and those issues.
Well, we'll see if we can live up to that high standard today. Today's presentation, we have a few slides to go through to talk about the laws controlling the issue of conflicts of interest in government agencies. Without further ado, there's the lawyer's disclaimer. This does not constitute legal advice because each actual legal situation is fact specific. So if this prompts any questions, please reach out to your normal legal advisor for specific legal advice. Today's agenda is basically two sections. I'm going to start by talking about conflicts of interest, the laws controlling conflicts of interest, and what we can and can't do under those laws. And then I'll throw to Bill, and Bill's going to talk about economic interest disclosures. It's the gifts rule and the Form 700 rule. And so that should take us through about a full hour. And without any further ado, like I said, I think we should just jump right in. Bill, why don't you start by telling us why we're here?
Well, it's interesting. You know, none of these laws are recent, right? We've had conflict of interest laws. We've had Form 700 type laws for many, many years. But what's really, the reason why this has become so much more of an issue is we've seen these municipal scandals. On the slide in front of you are individuals from the City of Bell scandal. So after the City of Bell, there was a lot more effort and energy placed into enforcing these conflict of interest rules and these reporting rules. And so really that's why we're here today, because it's really become much more of an issue that's facing our clients.
So jumping right in, let's talk about the basic rules under conflict of interest law. Starting with Government Code Section 1090. It's the formal anti-contracting law that says members of a government body shall not be financially interested in any contract made by them in their official capacity. So what that means for our school clients, our school employers, is anybody on the Board of Education or any of the higher administrators in the organization. And those people will be specifically identified in local conflict of interest codes. But any of those people must avoid entering into or even influencing the entry into any contract in which they have a financial interest. The simple rule on Government Code 1090 is to follow the money. If there's a contract being considered by your agency, and there's any appearance even, but any actual involvement that some of that money goes into the pocket of any of the identified designated individuals, what we call the code filers, then that contract is prohibited. It says very clearly, nor shall any state, county, or district, or judicial district, or city officers or employees be purchasers at sale of any purchase of property made by them in their official capacity. So the rule basically states that these identified individuals, these officials and these employees, can't be making any money in the contracts that they enter into in their official capacity. It goes on to say that, in case there's any question, it goes on to specifically describe which agencies are involved here, and a district in this case includes our local school agencies, both K-12 districts, community college districts, and also county offices of education, county superintendents. So this comes from 1090. We refer to it as the 1090 rule, and that's the basic conflict of interest rule in California. Some specific things about 1090. It does apply to all of our board members in our educational agencies, but also officers and designated employees, and sometimes even consultants. Who is actually included on the list is determined by local policy. None of those people may have any kind of financial interest in any of the contracts entered into by that Board of Education or that agency. And that also means they can't influence the entry into those contracts. That means no involvement in preliminary discussions, no part of the negotiations, no recommendations, none of that. There just cannot be a contract entered into by the agency where any of their employees or executives had a role and they have a financial interest. By the way, recusal is not enough. If a board member might have a financial interest in a company that's contracting with the agency, stepping away from the decision isn't enough, because mere membership on the board creates the implication that the agency should probably go ahead and enter into that contract as a favor to that person. And just the specter of that, just the implication of that is enough to trigger scrutiny under Government Code 1090. So even in those cases where a board member or a designated official might say, look, this is a contract, I'm going to fully disclose that I have a relationship with this vendor, that's just not enough. It doesn't guarantee that there won't be any influence, inappropriate influence, in the making of that contract. And out of the case law, we get the quote from the Thompson v. Call case, where the court said it's been suggested that mere knowledge of a fellow officer's interest may lead the other officers of that agency to favor an award of that contract which might benefit him. And just the appearance of that creates a prohibited 1090 conflict. So under 1090 analysis, there are three types of financial interests. One is the direct or indirect financial interest, and that just basically means where's the money going? It's either a direct or an indirect financial interest in a contract, and that creates the prohibition that we're talking about. So some examples of that are spouse's interest. If I'm a board member, I have a community property interest in my spouse's property, so my board cannot contract with my spouse's company because indirectly that money makes its way into my pocket, and that's a 1090, arguably a 1090 violation. Similarly, sons or daughters' business might be implicated if that son or daughter had financial ties to the board member, living in the house or some other financial tie. Being a stockholder, a major stockholder in an entity, in a vendor company, would also create a direct or perhaps an indirect, but certainly a financial interest that would prohibit a contract with that company. There's also such a thing as a remote interest. These are specifically designated relationships where even though there's not actual dollars going into pockets because of the relationship, there's a loose but identifiable tie between the official and the contracting company. Now, remote interests are allowed if you follow some specific requirements. Because they're so small, they're so remote, they're not prohibited by law. So when you look at Government Code Section 1091, it will tell you what the remote interests are, and it will tell you what you need to do to go ahead and make that contract. And that includes full disclosure of the relationship between the employee or the official and the vendor company, the contracting company. That disclosure has to be documented in the official record, so the minutes of the board meeting have to reflect that board member John Jones identified a potential remote interest. And then that person must disqualify themselves. And in our opinion, I think the safest way to disqualify yourself from a vote is to actually get up and leave the dais. Make it visible. Make sure the public can see that you are disqualifying yourself and you're not participating in any way in the formation of that contract, and then it will pass muster as a remote interest. Finally, under Government Code 1091.5, there is an interest that's called a non-interest. It gives some examples of things that are not to be considered financial interests. And there are several examples like a landlord-tenant relationship, other familiar relationships that don't implicate any kind of a financial entanglement. So distant relatives would be non-interests. And for these, there's no need to disclose at all. There are no formalities. You don't have to disqualify yourself. You don't have to announce. They are simply non-interests under the law and don't constitute a 1090 violation. There are some specific exceptions that apply to our school clients. And these are the questions that come up quite frequently. And the first is, am I allowed to vote on a collective bargaining agreement if it has a financial impact on myself or my household? And that might occur in a couple of different ways. The board member's spouse may be a member of the teacher's bargaining unit, and there are times where that's okay. We'll discuss that. But voting on that collective bargaining agreement might increase that person's salary, the spouse's salary, or might increase benefits. Also, board members have to set their own salaries and their own, and that's going to be the next example. It's not the collective bargaining example. But if it is a vote that applies to a group of employees across the board and not an individual vote on the spouse's own income, then it's allowable under this exception. Now, further on the spouse issue, there are some specific limitations because the law does prevent a spouse from entering employment with an agency if their spouse is already on the board. That's essentially entering in a contract that creates a financial benefit, and that board member would not be allowed to vote on that contract for his or her spouse to come into employment with that agency. And remember, it's not enough to recuse yourself either. Just the implication is enough to preclude any new employment relationship for a spouse of somebody who's on the board. I hope I described that clearly enough, but maybe as I go forward, here are the two exceptions to that. Where a spouse is already employed by the agency. So let's say I'm going to be a board member and my spouse has already been employed by the agency for at least 1 year. That's okay. I can then be put on the board. My spouse does not have to quit, doesn't have to resign from employment, and may remain employed. However, my spouse will be frozen in employment. No promotions, no advancements, not even advancement from probationary to permanent status. That person has to be frozen during the time that I'm on the board. If my spouse has not already been on in employment for up to a year, let's say for 6 months, and I get on the board, one of us has to quit. That's the way the law works. The spouse would have to remove themselves from employment for me to stay on the board in that circumstance. So there are some exceptions that I mentioned for both the remote interests and for non-interests. As I mentioned, for a remote interest, the agency can enter into the contract, but the officer must disclose the financial interest, describe why there's an interest there and why it's only a remote interest. That needs to be reflected and recorded in the official minutes, the official records of the board. And then finally, there must be a complete withdrawal and abstinence from any kind of participation in the decision, both in the preliminary stages and ultimately in voting for the contract. And then again, for non-interests under 1091.5, those formalities are not required. Under the conflict of interest law, there are some significant penalties, and if you've heard about the FCCP coming down on public agency officers and elected officials in the recent couple of years, this is what they use for that. There are penalties for violation of these conflict of interest rules. They can be monetary and imprisonment. Penalties can include barring from disqualification from any future public office. And perhaps most importantly, and I say that because sometimes big dollars are involved, any contract entered into in violation of Government Code 1090 is both void and voidable. It's void as a matter of law, but it's also subject to being voided by action from others. So a complaint could go to the district attorney saying they entered into a contract that's prohibited by 1090. The district attorney can actually bring action to void a contract. And the ramifications of that can be pretty severe. The vendor that entered into that contract would lose any compensation received, even if the services had already been rendered or property conveyed. So for example, if the contract was for the purchase of a fleet of trucks, the trucks stay with the agency and the vendor gets no dollars. That's ultimately the legal outcome that's prescribed under the law. Now, there are some remedies to try and fix that that are outside of the scope of this discussion, but on its face, the conflict of interest rule creates some significant potential penalties, and that's why we need to watch out for these things. So the second body of law, and there are three, there's your spoiler, the second body of law comes from the Political Reform Act that's found in a different part of the government code. And this is a little broader. It applies to conflicts of interest beyond just where the money goes. It's more about influence, influencing the creation of contracts and entering into relationships where that influence either is or appears to be inappropriate. Who's subject to these provisions? Any public official. So that means every member, officer, employee, or consultant of a state or local government agency. And as we know, that definitely includes school districts. Under the Political Reform Act, we say that the basic rule is no public official can participate in any government decision if there's a financial interest. So it goes beyond just the contracting question. No decision can be participated in where there's a financial interest. And this law actually provides some guidance. The law says that a financial interest exists when it's reasonable. It would be found reasonable that a decision would have a material financial effect on either that board member or a member of the immediate family. There are a couple of exceptions built into the law that kind of allow business to get done in kind of a necessary case. So it's called the rule of necessity. If there's a legal requirement that that particular board member, even though there may be an interest, a financial interest involved, there's a legal requirement for that person to participate, then there's an exception under the rule of necessity. But there's also requirements to disqualify, and we'll get to that here in just a second. Under the PRA, there are 6 specific types of financial interests. One has to do with business ownership, another with real property ownership in or near the jurisdiction. The third has to do with income, and that includes spouse's income. So any income over $500 within 12 months of the decision to be made would count as an interest that would potentially disqualify that board member from participating. Ownership of a business entity, either in a director, officer, owner, or management position, may preclude any kind of contracting with that entity. There's the gifts rule that Bill's going to talk about in a few minutes, and I believe most public agency officials are familiar with it. Hopefully you are. And that sets a limit for gifts that may be received from outside sources and that factor into the conflicts question. And then finally, the personal finances of the official and the immediate family. So anything that has to do with personal finances and would have a material impact on increasing the personal finances of an elected official do fall into the analysis for the Political Reform Act conflict of interest. If a person is disqualified under the PRA, the agency can still enter into these contracts. So that's a major difference between the PRA and Government Code 1090. They can still enter into the contract, but the interested official must disqualify, may not participate in any way in the decision, including the negotiation, discussions, and then of course the final vote on that decision. And that again has to be publicly announced at the board meeting. But again, there are some exceptions. Under the rule of necessity, if participation is legally required, then that supersedes the disqualification requirement. There are financial penalties and penal penalties because violations of the Political Reform Act are misdemeanors that can result in fines of up to $10,000, and again, also removal from the position and barring from future public office. So the final category are what we call the non-statutory conflicts of interest. You've probably heard the rule against appearance of impropriety. So that's what we call non-statutory or common law. These common law conflicts of interest arise mainly because of the appearance, and they're rooted in the idea that a government official's first duty is to the public and not to himself or herself. And so any appearance of self-dealing in their actions within their agency may give rise to a common law conflict of interest because of that appearance of impropriety. So again, the law has an expectation that the public officials are acting for the primary benefit of their constituents, and so any actions by a public official that reflect a private interest, whether it be financial or otherwise tangible, should not be seen to color their decisions, and that's what it must be avoided under the common law. There's no prohibition on a member voting or on an official voting on a matter in which they may have a common law conflict of interest, because again, it's just an appearance thing. This is really a self-policing situation where the individual member has to decide, how's it going to look if I vote on that ordinance or if I vote on that new policy? If it looks like I'm self-dealing, then I would be very wise to avoid that, because I don't want to come under scrutiny under any of these conflict of interest laws, including this common law conflict of interest. You got to avoid the appearance of impropriety. And the courts have said so. You've got to avoid both the actual statutory conflicts of interest, where we're talking money in pocket, but also any case where there's an appearance that you're self-dealing, the appearance of impropriety. And so our goal in applying all these rules is to limit the possibility that the agency will get challenged from the outside with allegations of self-dealing or even a specific violation. And so we try to behave accordingly and avoid the appearance of impropriety. I guess my favorite example from the case law on the appearance of impropriety is a case where I believe it was a city council member, owned a house on a hill overlooking the ocean, and he had a great view. And he voted on an ordinance that would preclude the people down the hill from him from building a structure higher than one story. And the court found that to be a pretty clear indicator that he was doing that mainly for his own benefit and not for others. And so that violated the common law appearance of impropriety rule. Can you think of any other examples in your experience?
Not so much the common law, but one of the plainest examples I ever saw of a conflict of interest was a district that we represent had their director of transportation also ran a car wash, and it's in a very small town. And that car wash that the transportation director owned had the contract with the school district to wash all of their vehicles. Well, that's one of the more obvious cases of conflict of interest. The thing that actually makes me more concerned, and I was going to ask you this, is my concern is sometimes people don't realize that they've stepped into a conflict of interest because, Mark talked a little bit about remote interest. I think you heard some of that. If you read the case law on the remote interest cases, they're very attenuated, and there's lots of different facts, and it becomes very complicated. So I wanted to ask you, new board members, what would be your advice to them to stay out of trouble on the conflicts? In other words, how do they stay alert to these potential issues?
Well, I think the best rule of thumb is put yourself in the position of the public, put yourself in the position of the media. And if you're involved in anything financially that touches your agency in any way, it's probably a real good idea to think of how it looks to the outside. What if you read about that in tomorrow's paper? If it looks like it's a little dicey, that there's some entanglement there, it's probably a good idea to either back away from that or at least check closely with legal counsel for a specific analysis. And I think that's probably the best advice I would give to new board members.
There's one other option too that I used to think never worked, but we tried it more recently. Under the Political Reform Act, which Mark spoke of, there's actually a 1-800 number you can call and say, hey, I've got this and this going on. What do you think? Now, they're going to be very conservative in their advice. They're not going to tell you, you're fine when you're not. But what they'll do is provide you with a written, essentially, opinion. And as long as you act in accordance with that written opinion, it's a defense, I believe, to criminal penalties.
It is. It's like a get-out-of-jail-free card. So reach out to the FPPC, and you can rely on anything that they give you.
And also, if you have any questions, I would recommend speaking to your superintendent, and they may need to contact legal counsel. These are very complicated issues. And the problem with these conflicts of interest is you can't unring the bell. And so one of the things that can happen, for example, here's an example we'll see from time to time. Okay, a board member will say, look, my spouse would very much like to work for the school district. Now they're saying this to the other board members. I'm going to resign because I don't want there to be any conflict. But in certain circumstances, the fact that they've already said that has created the conflict. It's already a conflict. And so it's important, if you have questions, to ask, call the Political Reform Act 1-800 number, talk to your superintendent, and they can confer with legal counsel, because really it's something you need to catch before you're in it. You can't really extricate yourself.
And that takes us all the way through the conflict of interest background. I'd say where the rubber meets the road on these things is in the economic interest disclosures, and Bill's going to talk about that.
Okay, so now we're going to talk about gifts and Form 700s. This is part of the Political Reform Act, which was the second set of laws that Mark talked about. By the way, when we analyze these laws, just so you know, if we were to write an opinion letter, we start with the most stringent, and then we go to the least stringent. And the most stringent is always 1090. So when you go to Government Code 1090, if it violates 1090, it definitely also violates the Political Reform Act. And so we're going through these in the same order that we look at them when we're analyzing issues. Okay, so let's talk about the Form 700. Form 700s need to be filed upon taking office and annually. And it requires certain disclosures about your income, financial interests, and gifts you've received. And it informs the public potentially about conflicts. Form 700s are public documents, so anybody can make a request and receive your Form 700s. So the public can see if there's potential issues with conflicts, and it also, in filling out the form, allows you to see potential conflicts. It's signed under penalty of perjury, and that's very important, and I'll tell you why a little later. And of course, as I said, it becomes a public document. I can tell you, in some school districts, I have to file Form 700, so I've done it too, and it can be a little uncomfortable because you have to list certain categories about your income and financial interest, but it is overall a pretty easy process. Okay, so when do you file? Within 30 days of taking office and within 30 days of leaving office. You also have to file every year by April 1st. Where do you file? Well, it differs from county to county, but I believe in San Bernardino County, they do not use electronic filing. So what you would need to do is file your Form 700 with your agency's filing officer. Usually, by the way, that's the superintendent's secretary in most cases. And in San Diego County, though, for example, they have an online system, which is really great because you only have to fill out one form and then you can click all the districts that you need to do it for. And who files? Who files? Well, it differs from district to district because what happens is there are certain what are called statutory filers. Your superintendent and board members are always going to have to file. But then they leave it up to the school district to decide who else is going to file. And so every school district has what's called a conflict of interest code. And that talks about who are the people who need to file Form 700s. So if it ever comes up for Mark and I that one of the two of us has to file, that is because their conflict of interest code requires it, not because we're listed in the law. All right, so let's talk a little bit about gifts. And this is really the number one area that as a board member, you're really going to need to be diligent. So what's a gift, okay? A gift is anything that provides a personal benefit for which you do not provide goods or service of equal value, okay? So it's a freebie that provides a benefit. And here's the rule. No elected official or candidate or designated filer of a local agency can receive gifts from any one source in excess of 520 in a single calendar year. And so I want to be clear, entity, okay? Now, I'm going to use Mark and I as examples, but I want to tell you that as a vendor to school districts, we take this very seriously, and we would never put our clients in a position where we would cause them to violate the conflict of interest code. So even though I'm going to use Mark and I several times as examples, just know that they're just hypothetical. So let's say Mark takes you out to dinner, and that's $200, and I take you later out to dinner, and that's $200. One, I'd like to know where you're going to dinner because that sounds like a really good place. But two, that is not a $200 gift. That is a $400 gift because Mark and I are part of the same entity. And so you need to be careful there, particularly if you use multiple employees from the same vendor. Now, that's the law on the amount of gifts, the $520 amount. Now, understand that if the gift goes over $520, you are no longer able to participate in any decisions involving that vendor, and effectively, the vendor can't do business with your organization. That's one requirement. There's also the reporting requirement, and that's any gift aggregating $50 from a single source must be listed as a gift. What does that mean, aggregating? That means that if I take you to lunch 6 times, and unlike dinner where you spend $200, we're spending $10 at lunch. We're going to like Arby's. Let's say we go to Arby's 6 times. That's $60. Even though each lunch was $10, you need to report the $60 worth of Arby's. I hope that makes sense. Okay, here's what constitutes gifts. Well, meals, very common. Tickets to sporting events, parking, rebates, transportation, golf, forgiving loans or debts, anything that conveys a value to somebody is a gift. And they're reportable regardless of where the gift comes from. If it comes from out of state, if you receive it, you still need to report it. What are not gifts? And I'm going to ask Mark. I'm going to ask you a question. I'm sorry. I'm going to throw one at you here. All right. So gifts not used within 30 days, returned to the donor or given to charity. Those don't count. Here's my question for you. Let's say I get a gift of a ticket to a Dodgers game, okay? And I don't go, and the time for the game passes, but I don't return it. Would you consider that reportable still?
It is reportable because it's a gift that had value. The only way, and I guess here's the best explanation. You know, one could argue that if I didn't use it, it has no value now. But really, the way the law is written, the only way to avoid having to report that gift is to give it back.
Okay.
And so I believe that would be a reportable gift.
I err on the same side of caution as you do. I agree. I think if you get a ticket to a sporting event, you actually have to return it. You can't just not use it. That's what I believe to be the case.
And you actually raise an incredibly good point. On these things, we always need to err on the side of caution because the consequences can be pretty severe.
I agree. All right, so what do you need to disclose? Well, the form is going to tell you what you need to disclose. You know, the name, a description of the gift, the fair market value of the gift, and the date on which the gift was received. So another area where I think you need to be careful. I get concerned when the value of the gift and its actual market value differ. My recommendation is report the higher of the two values. What is an example? Well, almost any sporting event is going to have a face value for the ticket, but to buy them in the open market, they may be much more expensive. I recommend using the higher number just to be safe. Okay. So this is the rule that Mark and I were talking about a little bit. If you return it within 30 days, you don't have to report it. And I've seen that happen where a school board member will say, hey, I received this from this vendor. It's great, but should I keep it? And I would let them know, hey, that's going to be reportable, but it won't violate. It's not over $500. Well, in that case, the board member may or may not. They'll either report it or they can return it. And that's certainly an option that you have. Reciprocal exchanges. I want to talk a little bit about reciprocal exchanges. They typically don't count. So let's say, in this case, Mark is a school board member. I am the school district lawyer. Let's say Mark is a superintendent and I'm a school district lawyer. And I take Mark out to lunch, and every time we go to lunch, we go to Denny's, and I pay once, Mark pays once, I pay once, Mark pays once. That's fine. No problems there. I had read about some cases in the past where people were trying to argue that there were reciprocal exchanges when the dollar values were dramatically different. Let's just dispel any of that. The amounts of the reciprocal exchanges have to be pretty close. So if every time Mark and I go to lunch, he buys for me at Denny's, and then I go and buy for him at Ruth's Chris, that's not a reciprocal exchange, okay? Wedding attendance. This is a funny one because I got married as a lawyer. So I was already a practicing lawyer and I got married. Fun fact, and it has nothing to do with this presentation, but Mr. Thompson and I went on my first date with my wife together because we were at a USC game and I was nervous and I called him and he said, why don't you come hang out with us? And so we hung out the whole day and I got married 2 years later. Anyways.
I mean, it's good luck charm.
Yeah, Mark's my good luck charm. But inviting people to your wedding, that's okay. And here's why. Because the law presumes that you're not going to throw a wedding just to get gifts from people who are, providing who are providing business to your organization. Now to be clear, that's fine, except sometimes you need to be careful with things like if the gift from one vendor is excessive, that might be something that you've got to think about and potentially report, okay? Like there's a case out of, I believe, it's a California case where there was a dollar dance for a filer's daughter, and of course when the vendors got up, there were $100 bills and everything, and so that created some potential issues. But generally, you can invite your not your clients, but potentially as a lawyer, I could invite you to my wedding and you wouldn't have to report that wedding invitation. I don't plan on getting married again, but if I were to, then you wouldn't have to report that.
We'll have to double date again.
Yeah, there you go. I'm not going to get married again. Well, I'm still married, but not until I go on a double date with Mark. All right. Let's talk about bereavement offerings, same kind of rule. Typical bereavement offerings are not reportable as gifts. So what is a typical bereavement offering? Flowers. Smaller amounts of money, I think, are acceptable. Food, things like that. Bereavement gifts that are excessive would be reportable. And then the best friend forever clause. I have a friend who is a school administrator, and he and I became friends not because he's a school administrator, but because of things outside of that. Our families are friends. So we're friends, okay? And so if he and I get together, we can spend money on each other, we can go to dinner, and it's not the same. I don't have to report that. He doesn't have to report that because our friendship originated and is based outside of our professional relationship. So that's the example. And then home hospitality. This is an interesting one. You can have people over for dinner, okay? And you can have dinner parties and things like that as long as the people who are coming over you have a relationship with outside of your official capacities. That does not apply, by the way, if you are a lobbyist, but this wouldn't apply to any of you in this presentation. But lobbyists cannot do that. So, enforcement. There are criminal sanctions. Mark's talked about that. The other thing, and we've seen a lot of this, is fines. So one of the things that happened, about 9 years ago now, I would say, they subpoenaed certain records from certain vendors and then looked at people who had attended events that were sponsored and went and took all of them and pulled their Form 700s to see if they reported it. And those who didn't received a fine and their name was publicized. And so that's what we've seen primarily. The fines are not, they range from as low as like $100, and some of them are over $1,000. But that is a definite real-world potential penalty for not reporting something. And so from that standpoint, I want to give some advice, and then I want to talk to Mark a little bit about some issues. But here's the advice I want to give. Okay, first of all, when you're looking at gifts, really weigh the option of whether that's something that you want to do. It could be, you can make an honest mistake and forget to report something, and the next thing you know, it comes back years later as a fine. So I would tell you this. Really ask yourself if you want to do or want to receive the gift. If you say you do, make a note of it somehow on your own. I've seen some board members actually told me they start filling out their Form 700s as they go. So it's like, oh, I just went to dinner with that person. I need to go put that on my form. And they pull it out and they put it on their form. Do whatever works for you, but just make sure you make a note of it so you don't forget. And then the last thing is you've got to keep an eye on the dollar amounts. And they can add up. A concert here, a lunch here, they add up. So be very cognizant of that. And then I want to turn it over to Mark and ask you, for your input.
Well, a couple of things now that I'm thinking about it. One of them is I heard a couple of years ago there's an app, and I don't know what it's called. I apologize. We should find out and put it in the materials. But I believe there's an app that's available, probably under Form 700 or something like that, that hopefully is an easy utility for you to use to just punch in your information every time you receive a gift. As far as advice, I think the way that I would boil all this down is you got to remember that there's three things to worry about with gifts. One is whether it's reportable. And as Bill pointed out, if it's over $50 in the aggregate, you have to report it. It's perfectly legal, but you have to report it, and you don't want to miss that. The second thing is there's a hard cap on the maximum amount, which for the current year is $520, and it goes up every 2 years. That is a never exceed number. You can't ever go over $520 during a reporting period, which is the calendar year. And then thirdly, there's a must not contract limit. And my best research is that number is still 500. It's not 520. But if you go over 500, not only have you come close to breaking the total limit, but for 12 months from that point, you cannot contract with the person who gave you the gift. Right. So again, there's a reporting limit, a maximum limit, and a no contract limit that all get tied up into these reporting requirements and the gift limit. And I think the other thing to be cognizant of is, again, it is legal. You don't have to ask the first question, should I not do this because it's illegal? But Bill's right. There's a limit to which you're comfortable as an official receiving that gift. And if you're not comfortable but you still want to go to the game, just pay for the ticket. If you pay for it, it's not a gift. If you give it back, it's not a gift. But I think that's the advice that I would give.
The only other thing I wanted to give is one area where board members can and really other filers can run into troubles when you go to these large events like CSBA or things like that. And here's what a true story that I heard from a board member. Hey, I'm with my team. I'm out here. The next thing you know, we're meeting up with these folks, and now I'm on a bus, and I'm going to a restaurant, and I'm ordering food, and next thing, and I realized, oh my gosh, it was over $50. So what do? And here's the answer. If you go to a hospitality suite and you have a few shrimp and you have a drink, is that reportable? Potentially yes. The answer is potentially yes. And I would say this, what we do as a firm is we put a sign up when you walk in and say, participation in this event would confer a benefit, and we have the amount. It's always under $50.
$49.
Yeah. But there's something there that says, hey, if you attend this event, here's what we're recommending you report. And I think that's a good thing for all vendors. I think most of them do it now. If they don't, ask. Say, hey, I'm going out tonight. Can you give me the approximate value? And ask, and then just report that amount.
Now, if simply setting foot through that door doesn't necessarily invoke the gift requirement, because there is a de minimis rule,
right?
Which means if you show up, I think some people call it the one shrimp rule too.
Yes, I've heard it called the one shrimp.
If you show up and you have one shrimp and just a soft drink and no cocktails, and you stay for a few minutes, that's de minimis and would not be reportable. It's if you show up and partake in the buffet and have a couple of drinks, beverages, adult or otherwise, sit around and listen to the music, that's when you invoke that gift requirement, and then that's when you want to ask the vendor, what's the retail value of my participation in this event?
One shrimp, no problem. Two shrimps, big problem. So that really covers Form 700 and the gifts. I did want to say this, I've been watching the media, and in fact, Mark and I were talking about the Saturday Night Live bit that occurred last weekend with the school board meetings. I just want to compliment all of you on your ability to maintain composure, maintain you know, just maintain, you know, you keep doing your jobs in spite of all of the negative energy that's getting thrown unfairly at school boards right now. So I just, you know, I just want to compliment all of you for that, because it's just such a tough time right now, and just, you know, keep doing a good job.
Thank you, everybody.